Good afternoon, everyone. My name is Benjamin, and today we're talking a little bit about some Supreme Court news because guess what? We've actually got Supreme Court news. Well, some of it is actually old news, and some of it's actually new news. So, the court. So, I'm going to go ahead and just give a breakdown of the three things I want to talk about today. So, first is a decision was made regarding Fourth Amendment and community protection and caregiving exception in regards to the Fourth Amendment protection against unwarranted searches and seizures. Second is the New York concealed carry case. And the third is about the news that came today that I found out while I was at lunch from work that the Supreme Court is going to be hearing Mississippi's abortion regulations that have been halted by the Fifth Circuit. So, by the way, this is a photo taken in 2021 with all of the justices: Roberts, Thomas, Breyer, Alito, Sotomayor, Kagan, Gorsuch, Kavanaugh, and Barrett, and that's in order of seniority. So let's start with actually, before I get into it, like, a comment, and subscription would greatly be appreciated. Important links are in the description. And liking and commenting help the algorithm not hate me. And subscribing, hey, I'd like to reach 1,000 subscribers by the end of the year because that'll allow me cool new features like, I think, memberships and super chats and stream. I'm not entirely positive on that, but I think that's actually a thing that comes along with it. And if I get memberships, I may try and design some emojis, because why not? That'd be cool. Anyway, we're rocking the bow tie because bow ties are cool. Anyway, so let's get in with it. That sounded wrong. Let's dive into the first thing, which is a decision was released regarding the Fourth Amendment and unwarranted searches and seizures, and specifically regarding the caregiving or caretaking or community protection exemption. Basically, sometimes, cops can enter your home if there is a reasonable fear that there is an imminent danger to someone in that residence, right? And they can seize anything that would provide that imminent danger within reason, of course. However, there was a rather interesting case out of Massachusetts, if I remember correctly, it was Massachusetts, where a man was having an argument with his wife. He took a gun, placed it on the table, and said, then why don't you shoot me and get it over with? And basically put me out of my misery. I think that was what it was exactly said, but the point is, it doesn't matter. The wife went and spent the night at a motel and called the police. Police actually transported him to a facility to see, is he really actually suicidal, or did he just lose his temper in an argument? And both parties agreed, and the man agreed to allowing the cops to search the home, provided they didn't confiscate his gun. Guess what the cops did? They seized the weapons. Anyway, it made it all the way up to Supreme Court. The lower circuit, I believe it was the First Circuit, upheld this seizure. And it got up to the Supreme Court. They heard oral arguments last term, if I remember correctly, and they released a decision. It was 9-0. Yes, a unanimous opinion, a unanimous decision. not a unanimous opinion. Actually, if I remember if I remember the article I read about it correctly, every justice on the conservative wing wrote an opinion. So Roberts wrote an opinion, Thomas wrote an opinion, which is weird that Roberts wrote an opinion because the official majority opinion was Thomas. This is the part that gets really weird. Okay, Thomas wrote an opinion, Alito wrote an opinion, Gorsuch wrote an opinion, Kavanaugh wrote an opinion. I don't remember if Barrett wrote an opinion. Really weird case, right? Breyer joined Roberts. I forget who Kagan and Sotomayor joined. But it was really weird to assign the majority opinion to Thomas and then write your own opinion. Okay, I'm interested now. It's likely Thomas was going to write his own opinion anyway, but that's beside the point. Because Thomas doesn't normally get majority or dissenting opinions, particularly of major cases. And I would actually constitute this as a major and an important case. That's why I'm talking about it. And the reason why it's kind of important is Alito's concurrence stated that it implicates but does not address this decision red flag laws. Basically, he's saying, hey, some of these red flag laws may need judicial review because from what I've read, some of them are not in keeping with the Fourth Amendment, let alone the 14th Amendment. But the 14th is what would be used to make the Fourth Amendment apply to the states in this case, through the process of incorporation. But yeah, Thomas doesn't write a lot of majority or dissenting opinions. He writes a ton of concurrences. But the reason why he doesn't write a lot of majority or dissenting opinions is because his opinion may be too conservative for most of the court. The other reason why is he tends to be a bit more forceful, a bit more direct, and I think in most legal circles they would actually describe it as controversial with regards to how he authors his opinions and how far he takes them. Now that is partially because of the way he interprets the Constitution. When he says he's a textualist, he takes that as strictly as possible. That said, there are areas where I wouldn't describe him as strictly textualist. Student speech is a good example. And it's an example where I disagree with him. But then again, I tend to side with the Hugo Blacks of the world on free speech. And for anybody who has studied court history, they know exactly what that means when somebody says they agree with Hugo Black on free speech. But anyway, so talking about the two upcoming cases, we'll start with the one that's going to be heard, I want to say in May, but it might be heard in October. I don't remember which sitting it's going to be held in. I should, but sometimes these things change on the fly. This is a case regarding New York's concealed carry laws. And specifically it has to do with the provision of requiring a just, or not a just cause, but a good cause or a good reason to want to carry a firearm in public. And New York cites examples such as having a recognized, the state recognizes that you have a stalker and you have genuine fear for your safety because of this. That is supposedly a reason for New York to grant a concealed carry permit, or any carry permit, because I think open carry is completely banned outside of hunting or at the shooting range in New York, but whatever. Obviously, hunting and shooting, that requires a different permit, and that only permits you to go hunting or to the shooting range with your weapon, if you're going to be carrying it. But another example of a good cause to the state of New York is, of course, if your job requires it. Say you work at a bank and have to transport money. That would be an example. Or are a security guard at certain types of locations. That would be another good cause. And I'm not sure if that allows you to carry off the job, but it certainly allows you to carry on the job. But effectively, New York is a no-carry state unless you fall into one of a few categories. One, you somehow happen to be in a county where the sheriff is sympathetic to the Second Amendment. Because the local police departments, I believe, are the issuing authority. Basically, they're the ones who evaluate it. Or maybe it's the judge, or whoever's in charge of I think it's done by the county level. I may be slightly wrong on that. I don't know exactly how New York law works, but in Virginia, each circuit's county approves of concealed carry permits. And Virginia is a shall issue state. So basically, if you qualify, you're going to get your permit. If you apply for it, obviously. New York is much different. But that's one way, is if you somehow happen to be in a location where the county won't deny you your permit. Another would be to somehow have a miracle where the state says, yes, you do actually have a reasonable fear for your safety. Because guess what? Even if you do have what would on paper appear to be a reasonable fear for your safety, New York can still deny you your permit. Because guess what? General self-defense is not considered a good cause in New York. As silly as that sounds. Another would be if you are extremely well connected, such as knowing the governor or important local bigwigs or being a celebrity of sorts. That is a way to get your carry permit in New York. And who does this leave out? Basically, it leaves out poor people, people who live in violent neighborhoods, because guess what? New York does not consider general self-defense in a violent neighborhood to be a good cause. And that tends to mean, statistically speaking, African Americans get left out of being legally allowed to carry in New York. The average person who believes it improves their and the safety of them and the people around them. So, yeah. I'm going to be honest, I see this law getting struck down because I don't really see how you get Roberts and one more justice on the right to flip. Because I'm not even sure who the most likely to flip would be, because it's all pretty unlikely. Alito wasn't the one who would have pressured Scalia to narrow his DC versus Heller opinion. Thomas, he's going to absolutely vote for striking it down because, well, Thomas has said that the court has treated the Second Amendment like a second-class right for years now. Kavanaugh, he wrote, I want to say he wrote the circuit court case that became DC versus Heller, or in dissent that would have expanded Heller, basically. So I don't see him flipping. Gorsuch, he's very civil libertarian, and I think he has one or two very pro-gun decisions in his past. And Barrett, who said that nonviolent felons shouldn't lose their Second Amendment rights. So basically, if you do a spot at tax evasion, the Second Amendment still protects your right to own a gun. Only violent felons and domestic abusers should be prevented from owning guns. So, yeah, Kavanaugh, Thomas, and Barrett, they're not changing. They're not going to flip to uphold this law. Gorsuch almost certainly won't, unless my read of him is very wrong. Alito probably won't. So that leaves Roberts, who is kind of up in the air. I could see him siding on either side, but I think he doesn't want Thomas to be the one to assign it, because Thomas, again, with a case like this, Roberts may want to assign the majority to someone who's going to have a bit more nuance, if that makes any sense. That said, you may actually get a flip from the liberals, and I'll explain this why. Breyer won't flip. He's going to support he's going to uphold the decision. Or uphold the New York law. I don't see a reasonable way to convince him that that the law is unconstitutional. He's wrong, but he's entitled to his opinion, and his opinion actually matters because he's on the high court. Sotomayor, she might flip, because, well, the way the law is enforced can be described as discriminatory. Certainly on poorer communities and in the large cities, those tend to be heavily minority-based. And Sotomayor is a very big believer in the idea of equal protection under the law. And that means laws should apply equally to the highest of the high and the lowest of the low. And so Sotomayor may say, listen, the execution of this law is certainly unconstitutional. Whether or not the law itself is, who knows? So she may write a concurrence. Or she may dissent, but, write a different dissent than, say, what Breyer might. Simply saying this law is unconstitutional, or saying this law is constitutional, but the enforcement of it isn't. Kagan is also, in my opinion, a bit of a swing vote, because she's kind of sympathetic towards building coalitions. So she may want to join in this opinion with the majority in order to, say, build some good faith with, say, a Barrett, Gorsuch, a Kavanaugh. That said, she also may be more sympathetic to Second Amendment issues from the conservative perspective, because when she first joined the court, she went up and started a tradition where, I think it was like an every year tradition, where her and Scalia would go on a hunt somewhere. And yeah, And she tells that story because she was being asked by a Republican about guns, and had you ever been hunting? Have you ever shot a gun? And she was like, well, no, I haven't done any of those things. And she's like, you know what? Maybe you should take me on a hunt sometime. And she walked back and said, well, maybe not you, but maybe it would be a good idea for me to familiarize myself with this. And she's the type of person who, hey, maybe that affects her opinion. I don't know. I'm not her. But it's definitely, even if she is still in favor of more gun control, including this law, it does demonstrate that she is interested in understanding the other side of the argument, not just bashing your head against the wall and saying, no, you're wrong, we need this, 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 and this, and any argument you bring is invalid. No, she's like, okay, well, here's where I disagree, here's why I disagree, we're free to disagree. There's a difference. One is intelligent, what Kagan would do, and what I think she would do in this situation. And the other is what the overwhelming majority of gun control advocates believe. So, yeah. Moving on, the Mississippi abortion law case. This one is very strict. Maybe too strict even for the conservatives, but we'll still kind of discuss it. I can see Thomas saying no because he's kind of explained he wants Roe v. Wade overturned completely. So he's, of course, going to be on that side. And by the way, I don't see the three liberals voting to uphold the law, by the Mississippi law, by the way. Breyer, Kagan, and Sotomayor they're gonna vote, all three of them, to keep the law stricken. Alito, I could see him siding with the liberals. I could see him siding with the conservatives, mostly because of how strict the law is. Because, wow, is it strict. Gorsuch, the same thing, actually. Kavanaugh and Barrett, I could see aligning with Thomas on this. And Roberts, I almost certainly see siding with the liberals, unless Gorsuch and Alito side with Thomas. In which case, Roberts, wanting a much more narrow and focused opinion rather than what Thomas would do, would probably side with the majority. Again, because Roberts might not want Thomas to write the opinion that would uphold Mississippi's abortion law, because Thomas would use it as an opportunity to completely strike Roe v. Wade from the books. And Roberts, I think, is more inclined to either slowly chip away at Roe v. Wade or leave some parts of it some parts of it intact. Basically saying, listen, the court has taken it way too far in the past, but they probably got the general direction correct on initial review. Whereas Thomas says, no. It was wrong, and it needs to be wrong. And by the way, Scalia actually agreed with that thinking. So, yeah. Anyway, I'm going to go ahead and end it here because I've rambled on for far too long. Take it easy, y'all. Have a very lovely evening. I'll see y'all next time.